Okay, good morning, everyone. It's 10:46. I'm David Goldstein of Certilman Balin, Adler and Hyman LLP. I'm the founder of the nonprofit tax-exempt religious organizations practice group, and I welcome you all. And I'm glad you could join us. And let's get started. So today's topic is going to be the impact of the pandemic on your organization's corporate governance. And in particular, we're going to focus on a legal update on changes in the legal realm, and particularly focused on the not-for-profit corporation law, New York State's law that governs nonprofits. We're going to look at what has changed permanently as a result of the pandemic, what has been adjusted temporarily, and what nonprofits should be focused on. And in particular, we're going to look at some traps that nonprofits can fall into, and we'll try and flag those to make sure that no one on the call falls into those traps. So what has changed permanently? And I think that's going to be a very short discussion, as you're going to see. The answer to that question is nothing. There have been no permanent changes. The only changes are temporary changes that are tied to the state of emergency that exists in New York State at the current time. So let's look at some of those temporary adjustments to the law. There have been three types of legal and regulatory relief during the pandemic, and those are governor's executive orders, a bill enacted by the legislature, which actually went into law on June 17th, and so very recent, and then there's been some guidance from the Attorney General's Charities Bureau. The governor issued Executive Order 202.18 on April 16th. And in a nutshell, the part of that order that applies to nonprofits is very small. And in fact, we're going to see is incredibly narrow. It modifies, during the state disaster emergency, Section 603B of the Not-for-Profit Corporation Law to the extent necessary to permit annual meetings of members to be held remotely or by electronic means. It was extended twice by Executive Order 20229 and 20239, and that extension currently, the last one, 20239, runs to July 7th, 2020. It may, in fact, not be extended further because we're going to see that the legislation that went into effect on June 17th actually covers the same ground and more. But as of now, it's still in effect. I want to mention that in the supplementary materials that are provided as part of today's program, you've got a copy of 202.18 as well as 29 and 39. So you can take a look at those. And in substance, I highlighted the term annual meeting of and members because this executive order is incredibly narrow. It only talks about annual meetings and, in fact, annual meetings of members. Under the law as it exists, without this executive order and without the legislation that we're going to cover in a minute, annual meetings of members needed to be in person. You couldn't have if your membership nonprofit, your membership meeting could not be held remotely. It could not even include dial-in or video conference. It had to be at a place and in person. So the first action by the state was in the realm of nonprofit governance was this executive order that focused on annual meetings of members, and it shows the importance in the nonprofit governance scheme of members' rights. That was the thing that the state government thought had to be adjusted so that it could work during the pandemic. And the annual meeting in particular has a very important function, and we're going to talk about it in the context of board-only nonprofits, which I suspect many of you are. And what happens at the annual meeting of members and the annual meeting of the board, if you don't have members, is you have every year there needs to be an election of directors. Those are the two things that must happen at the annual meeting: election of directors, number one; number two, an annual financial report. And we'll get into that in a little bit more detail shortly. So 202.18, this executive order, which is in effect till July 7th, and may be extended further. It temporarily allows participation by video conference and conference call. Without this temporary modification, as we said, and once this temporary modification goes away, annual meetings of members need to be held at a place. That's what the statute says. The meeting of members has to be at a place, which means in person at a physical location, and does not allow for video conference or conference calling as part of the annual meeting. So if you're a board-only nonprofit, you don't have members, the annual meeting is still a primary component, a fundamental component of nonprofit governance in New York State for nonprofits. In fact, it's the fundamental nonprofit governance event. Same as with members, the board gets elected at the annual meeting. That has to happen every year, and there's an annual financial report pursuant to the law. And the one thing to note with an annual meeting of the board, participation by video conference and conference call are always permissible as long as they're not prohibited by an organization's bylaws or certificate of incorporation. So I'm just going to pop to the questions, just make sure that nobody's got any questions. Good. Okay, please feel free, by the way, to type questions in, and we'll try to answer those as we go along. So on June 17, 2020, Governor Cuomo signed Bill number S-8412 into law. It's effective immediately, and it lasts for the duration of the state disaster emergency. And during the state disaster emergency, the board can determine that meetings of members, again, we're only talking about members, that's what the state has adjusted here, can be held partially or solely by means of electronic communication. So this covers the same ground as the governor's executive order, and then it goes further, because if you remember, the executive order said we're talking about annual meetings of members, but only annual meetings. This includes the other type of meeting that a membership can have, which is a special meeting. So basically, this means that all membership meetings can be held by means of electronic communication, video conference, phone conference, combination of those during the existence of the emergency. Further, this legislation provides that the board, and this is important, we're going to see a little bit later, not just for membership meetings. This can be generalized beyond that, but to board meetings. But let's focus on the language as it applies to membership meetings initially. The board must implement reasonable measures to verify that each person participating electronically is a member or a proxy of a member. The board must provide each member participating with a reasonable opportunity to participate in the meeting, including an opportunity to propose, object to, and vote on a specific action to be taken by the members, and to see, read, or hear the proceedings substantially concurrently with those proceedings. That sounds pretty straightforward, and those of you who know me know that my mantra is governance. It's not rocket science. None of this is rocket science, but we're going to see in some fact patterns involving board meetings that something that seems pretty straightforward and simple can lead to some interesting complications and potential non-compliance. And then the third piece is the board has to record and maintain a record of any votes or other actions taken by electronic communication at the meeting. Straightforward, but we'll see that can get complicated. A similar provision in the same legislation that we're talking about, S-8412, a similar provision allows membership meetings by electronic communications. There are some technical distinctions there, and it's beyond our subject matter today. But if you're involved with a religious corporation, you should be aware that the same legislation does allow, again with some technical distinctions, religious corporations to have membership meetings electronically. That's critically important because, believe it or not, religious corporations are even more regulated than nonprofits. They are subject to the nonprofit corporation law and also the religious corporations law. And the need for membership approvals of various items, including things like refinancings and mortgages, arises way more frequently under the religious corporations law than it does just for nonprofits. So this relief allowing membership meetings electronically during this current emergency is really critical for religious corporations. Okay, back to nonprofits. So what have we seen so far? We've seen that the governor's executive orders and the state legislature's pandemic enactment address only membership meetings. In April, the Attorney General's Charities Bureau issued guidance, and the guidance was entitled Guidance for Conducting Virtual Meetings of Members of New York Not-for-Profit Corporations. So again, applies just to membership meetings. So I'm going to give you some highlights of the Attorney General's guidance on electronic meetings for members, with the note to keep in mind that what we're going to see in a minute is that these are relevant to board meetings as well, and we'll make that connection in a little bit. So, by the way, this guidance is included in your materials, and it's about 4 pages long, and it's very accessible, very easy to read, and very helpful. So I definitely recommend that everybody take a look at it. And again, you're going to see that it can be relevant to you even if you don't have members, even if you only have a board and not a membership. Okay, so one of the things that the guidance says that you need to do is give the members the option to dial in addition to the video conference option. And a lot of people do that as a matter of course, but some weren't doing that. So that's an important distinction to be aware of. Test the system in advance, again, not rocket science. Assure the ability of attendees to participate. And this is an interesting one, and I think most nonprofits were not doing this until this guidance came out. Appoint someone to assist members having trouble joining the meeting in real time and disseminate the phone number in advance. So the way to do that is with notice of meeting. Included in the legal notice of the meeting is a sentence that says if you're having trouble connecting during the meeting, or either before or during the meeting, feel free to call so-and-so at the following number, and having someone available by cell phone during the meeting to help people who have issues with connections or participation. And the Attorney General's guidance also highlights things like notice, which is critically important for any meeting, board or membership, keeping track of attendance, voting, and the importance of minutes of the meeting. So what does all of this tell us about board meetings? Because we've been talking up to now, and the terms of all of these various enactments are with respect to membership meetings. So for most of you who are associated with nonprofits that may not have a membership, how does this apply to board meetings? How can this assist us in conducting board meetings during this current emergency that we're going through? In fact, board meetings via video conference, which have been allowed for quite some time now, and were explicitly added to the statute in 2014 as part of the Nonprofit Revitalization Act. Board meetings via video conference have become ubiquitous during the pandemic. So I don't think I've been on a phone conference of a board in quite some time. Boards that before the pandemic routinely had their meetings via phone conference now, in fact, are doing the same meetings via video conference. But interestingly, as we've seen, no executive orders, legislation, or Attorney General's guidance has been issued on that directly applies to board meetings. Again, feel free to ask questions if you've got any. Okay, so bottom line is that the laws and procedural requirements regarding board meetings have not changed at all as a result of the pandemic. There's been no enactment, no guidance, no executive order that deals with those. So that means that requirements applicable to boards with respect to notice of meeting, quorum for meeting, and that's a critical component. Both notice and quorum are items that are often used as the basis for litigation and to dispute the authority of a board to do something because the notice wasn't proper, the quorum requirement wasn't met. Voting requirements, none of those has changed even an iota as a result of the emergency that we've been going through now, and even a couple of months ago when things were so desperate in New York State, nothing was changed. And even requirements which legally are known as supermajority voting requirements or supermajority quorum requirements, where you've got a higher threshold to approve something, sometimes in your bylaws, and more often as a result of a mandatory provision in the law that requires more than just a simple majority to approve a certain action. Those remain in effect and haven't been altered at all. And of course, the board's basic oversight responsibility and everything in the not-for-profit corporation law that applies to boards has been left unchanged, untweaked, unadjusted as a result of the pandemic. In red, you see at the bottom of the screen that you should always remember, I mentioned earlier in one of the enactments that we spoke about, the S8412, it talked about a proxy of a member. On the membership level, you're permitted to have proxies. A board can never, ever use proxies, something that's very confusing to boards. The concept of a proxy is something that a lot of people know, and so sometimes a director feels that it's very natural to give someone else, usually another director, his or her proxy, but that's absolutely contrary to the law, not permissible ever in a nonprofit board context. The concept underlying that is that each director under the law has fiduciary duties, and you can't give those fiduciary duties away. So concomitant with that is you can't give your right to vote away either. So a director can never, ever give anyone else a proxy. Okay. So on the board level, participation by video conference and conference call are always permissible under the law, as long as they are not prohibited by your bylaws or certificate of incorporation, which is why we see that Zoom-type conferences are commonplace now for boards, and conference calls were so widely used even before the current emergency. As we said, the recent Charities Bureau guidance and the legislation and executive order were aimed at membership meetings, but in particular, the Charities Bureau guidance and the legislation provide best practices for board meetings, and that's one way that that these enactments can be particularly helpful to board-only nonprofits, is providing a structure of best practices on how to handle virtual board meetings during the pandemic and going forward even after. So in particular, the option to dial into the video conference, so not video conferencing alone, but also providing in the notice of meeting that the board member has the option to dial in via phone number as well. That's an important best practice. As I highlighted earlier, appointing someone to assist board members who are having trouble joining the meeting and having that person available in real time, disseminating that phone number in advance in the meeting notice is a very important and useful best practice in conducting virtual board meetings. So in general, attention to notice, attention to attendance at the meeting, voting, keeping accurate records of voting, and having timely and accurate minutes is critical. And again, the notice and the minutes we see in the governance disputes that come through my door, and unfortunately there's a lot of them. We see notice and minutes playing critical roles. So that's really something, again, none of it's rocket science. It really requires a continuous attention to some of these governance procedures and requirements, and they're often used as ammunition against a board. So best practice is to follow the rules very carefully, and then basically what you're doing is taking those types of issues off the table so that they can't be used against the board going forward. And then providing each board member participating electronically with a reasonable opportunity to participate in the meeting, including an opportunity to propose, object to, and vote upon a specific action to be taken by the board, to see, read, or hear the proceedings of the meeting concurrently as they're happening. Again, as we said, none of this is rocket science, but then you'd be surprised at how often there are issues with some what seems to be a very basic premise. So I'm going to give you an insight just into some phone calls that I've had. Haven't had a lot of in-person conversations during these last few months, but phone calls that raise questions in terms of board meetings and governance and procedures during the pandemic. So these are actual questions that board members and officers and senior staff have posed to me. Got a board member in the hospital with coronavirus. He gave another board member his proxy. Is that okay? And I think we all know the answer to that based on what we said earlier. Absolutely impermissible. Pre-pandemic, during the pandemic, after the pandemic. Board member can never give another person his proxy. I had a call that 2 board members were sick and unable to participate, and this was when we were the epicenter of the virus, and so many people and families were struggling. I had a board where 2 board members were sick and not able to participate in the meeting. The board chair sent an email to the board suspending the quorum requirement for the next board meeting. That doesn't work. As we see, and those, the only tweaks to the law, the only place that the law was loosened was with respect to virtual membership meetings. And so there's no ability to suspend the quorum requirement under any circumstances, including currently during the pandemic. So another instance, at a board meeting, the board voted to suspend the applicability of the bylaws for just this one board meeting due to the pandemic. Again, there's no authority or ability to do that, and so that doesn't work. And any steps like that are incredibly dangerous, because anything that are done in reliance on a step that's not permitted is unauthorized and invalid. So basically, whatever happens at a board meeting, and frankly, in all of these situations, that problem was headed off because the board and the officers sought advice before the meeting, and then understood that they could take those steps, and in fact, basically all of the governance requirements were in place, and there was no ability to suspend or waive anything, and then took a step back and acted according to the rules. So this is a very practical and interesting problem, this next scenario, and it comes up continually now in the era of ubiquitous board video conferences. So you've got a large board, and the quorum for a video conference can be challenging. And I've been on lots of video conferences where this is the dynamic. There's lots of background noise. You've got board members who don't keep themselves muted in spite of continual pleas and requests. I've got one board where there are two members of the same family on the board, and they talk to each other continually during the meeting, and they maybe there's a technological inefficiency there, but they have either a resistance to or inability to properly mute themselves, and so you hear that conversation fairly continually during the meeting. So what do you do in a situation like that? Well, probably the best thing to do is to have the board chair or maybe the chair of the governance committee reach out to the people who are having difficulty muting themselves before the meeting offline to resolve the problem. But a shortcut, and shortcuts tend to cause issues, and this one would. What the board chair decided that she was going to do was to keep everyone muted but the board chair. And anyone presenting a report to the board also would be unmuted for that report. And the rest of the board, and it's a fairly large board, will only be unmuted for votes. And so if you think about the basic sort of democratic concept underlying board meetings and some of the language in the legislation, again, that applied to members, but certainly is an appropriate practice for the board, that board members need to be able to participate in meetings, object to things, propose things. There needs to be an open exchange. You could see how keeping everybody muted except the speakers that the chair decides should be unmuted at a particular point in time, that can lead to some problems and challenges the validity of the meeting and the actions taken. So that's something to be very conscious of and to tread very gently in that area. So again, just reminding people, feel free to ask questions. Something else I want to touch on in terms of board meetings during the pandemic is the primacy of the annual meeting. So even if you're a board-only nonprofit, no membership, the law still requires an annual meeting. It's mandatory every year. That requirement of a mandatory annual meeting has not been waived, tweaked, touched in any way. That is absolutely in place with no change. And that annual meeting has the same mandatory components as a membership annual meeting would: election of directors and an annual financial report. The annual financial report has mandatory components that are set forth in two sections of the not-for-profit corporation law, Section 519 and Section 513, and that's a variant. The annual financial report is a critically important piece of nonprofit governance and goes a long way to helping protect the board, because it's assuring appropriate information flow, and we'll hopefully have time to touch on information flow a little bit later. And the annual financial report has to have it can have more information, but the minimum information is laid out in those two sections of the law, and that's something to vet with your lawyer to make sure that your annual financial report meets all of those specific requirements. So a lot of nonprofits struggle, even in normal normal times, and where we don't have the kind of difficulties we have now, with the timing trap that is built in to Section 519 of the Not-for-Profit Corporation Law. That timing trap is basically that the annual financial report requirement in the law mandates that the financial information is presented for a 12-month fiscal period terminating not more than 6 months prior to the meeting. So if your fiscal year is the calendar year, then your financial information, so as not to be stale under the 6-month requirement, your financial information has to be presented at your annual meeting before the end of June so that you can use your year-end financials. And that's something that a lot of people aren't aware of, but that in fact accounts for the fact that June is my busiest month of the year because many of my clients schedule their annual meetings in June so that they can maximize the amount of time their accountant has to prepare the financial data, but still meet the not older than 6 months requirement. So I have a question that relates to something we touched on a moment ago, and I'm going to read the question and discuss the answer. Do you think it's acceptable to mute everyone in the context of a board meeting via video conference? Do you think it's acceptable to mute everyone except the board chair and the speaker if all board members have the ability to raise their hand or type a question in the chat area? And my reaction to that is yes, but that's gonna take a little bit of kind of going beyond that first tier of, well, yes, you've got the technological ability to raise your hand or type a question in a chat area. It's going to take a little bit of attention to making sure that everybody who's participating understands how to use that. And that might be something where there's a verbal conversation about that as part of the meeting, and that also is tied to some written instructions that are sent around. And then, of course, and this is easier said than done, there has to be very active monitoring of those mechanisms to make sure that that the people running the meeting are properly recognizing people who raise their hand or pose a question in a chat area. And that's another area where that real-time ability to call someone, if all else fails, I've got a question, I've got a problem, I need something aired that I haven't been able to say, and for whatever reason my technology is failing me, I can dial somebody up and say that there's something that I need to discuss, or that the board needs to hear or think about before we vote or before we go on, or we need to go back and deal with this. So that's I think another example of the board of proposition that some of this stuff seems very simple. Yeah, there's a raise your hand feature, but maybe some people don't know how or are uncomfortable using it. So we need to kind of go the extra mile to make sure that we have proper process and proper governance and democracy in our decision making. So another trap for the unwary that is something that pervades, I think, the heavy use of video conference. A lot of EDs and board chairs have been telling me that their inclination is to cut back on the amount of information flowing to directors and the length of meetings. There's really a conscious effort to keep meetings that are held via video conference more manageable. And I think there's an assumption, and on a personal level, I think it may be accurate, but at least it's my perception too, and I'm hearing this from a lot of executive directors and board chairs, not to mention board members, that meetings that have lots of information and are very lengthy are even less tolerable in a video format than in person. Long meetings with lots of information in person can be taxing, but somehow even a phone meeting, I think there's the sense and the perception that somehow in a video format, lengthy meetings are even more difficult for the participant than even a phone meeting. So what do you do? It's an understandable adjustment to cut back on the number of documents, the amount of reports, not wanting to have a 3.5-hour meeting or a 3-hour meeting or even a 2-hour meeting via video conference. That's an understandable concern and an understandable adjustment, but it creates a very dangerous dynamic because the timely and adequate flow of information to the board is required for the board's mandatory oversight function. And so an unintended consequence of an effort to keep the meetings from becoming painful via video conference because of their length and depth, an unintended consequence is it could set up the board and the officers for a breach of fiduciary duty claim because there was a lack of timely and sufficient information for the board to perform the oversight that it is required by law to perform. And what I want to mention there is that this type of a failure to have sufficient information to perform adequate oversight, both with respect to the amount of information and the timeliness of information, is a very common feature of breach of fiduciary duty lawsuits against directors. And you've got a couple of those in your materials. One is the Delphi University lawsuit where the entire board was sued for breach of fiduciary duty. That goes back into the late 1990s. That's in your materials. And then the more recent Dowling College lawsuit, where again the board was sued for breach of fiduciary duty, and that that also involved the lack of timely and sufficient information flowing to the board and claims of lack of appropriate oversight. So that highlights for us the fact that directors of nonprofits have fiduciary duties. These are legal duties under the law, and when those duties are not properly performed, there can be personal liability to individual directors. And the two lawsuits that I mentioned were in a college or university context, but it goes well beyond that context. And there's something in the materials, the Healing Arts Initiative lawsuit from 2016, and in fact, the lack of information flow is a very common allegation in lawsuits, and is something when our firm gets hired to sue a board, that's something that inevitably we find is an issue. So three fundamental legal duties of nonprofit directors under New York law: the duty of care, the duty of loyalty, and the duty of obedience. And those of you who've seen me speak before know that these are things that I always want to make sure are in our consciousness and have a spotlight, because they're so important to the functioning of a board and protection of board members. The last thing you want to see when you volunteer to serve on a nonprofit board and you support the organization both in terms of passion, time, effort, and very often financial contributions. The last thing you want to see for directors and officers in that case is that they wind up as targets of litigation that asserts personal liability for breach of any of these fiduciary duties. So it's critical to be aware of these from day one and to make sure that that the board acts in a way that conforms with these responsibilities. So the duty of care is basically the oversight function, and this is enunciated in Section 717A of the Non-for-Profit Corporation Law. Basically, it holds that question. I think see that there's a question, but I believe the question that I see has been answered. And so, okay, if there's another question, please feel free to let me know. I think I just see that one question. Good. Okay. Duty of care. A director has to discharge the duties of his or her position in good faith and with the care that an ordinarily prudent person in a like position would exercise under similar circumstances. And you can't do that unless you go to board meetings, read the documents. This kind of ties in with information flow. You're familiar with both the organization's finances and its activities. There's no way that you can perform that oversight function without doing all of that. And if you look in your materials at the Healing Arts Initiative lawsuit, I believe what you have included is the summons in that lawsuit, and it's 2 pages long, and the substance of it is pretty much all in one paragraph, and it lays out the oversight function, and it says that there was a financial fraud in this organization that did tremendous damage to the organization, and each of the members of the board of directors was sued personally as a result of this financial fraud. And what the summons contends is the directors had an oversight responsibility, and they failed to discharge that in a way that a prudent person would under similar circumstances, and they were therefore responsible for the fraud and the damages that occurred as a result. So that's a good thing to take a look at. Very short yet powerful, and ties directly into this issue of timely flow of adequate information, and is something to keep in mind when we're trying to decide how to handle board meetings and the amount of information and length of time during the pandemic. What I think the answer has to be is that we can't go from a 3-hour meeting to a meeting that's an hour and a half, and that's the end of the story. What we may need to do is have 2 separate meetings that are each an hour and a half. But there's a certain amount of inflexibility in terms of cutting back on necessary information flow to the board, and that's the line that we really need to keep in mind. In your materials, I tried to provide something of a roadmap for the duty of care. In particular, there's a publication that I like to distribute the way some people hand out their business cards. I hand out right from the start the responsibilities of directors of not-for-profit corporations to Charities Bureau, Attorney General's Charities Bureau publication, and it's really a wonderful, easy to read, written for non-lawyers, and it's very accessible publication that tries to give directors a sense of how do you fulfill these fiduciary duties that you have. So that's something that every nonprofit director should read at least once a year, not just once in a lifetime, but at least once a year. We talked about the Delphi lawsuit and the Dowling lawsuit. Those are both in your materials. There's a Charities Bureau publication on internal controls and financial accountability for nonprofit boards. The role of internal controls and policies and procedures are critical in the board's oversight function, and policies and procedures are something for the board to develop with your accountant and with your counsel. Critical that your accounting firm have expertise and experience working with nonprofits, and one of the ways that that's going to manifest itself is in the internal controls and the policies and procedures that that you put in place to assure adequate control, and you monitor those, and that's the oversight function, and a critical piece of the oversight role and function is the audit oversight. And I note that the only committee that has its own section of the Not-for-Profit Corporation Law, 712-A, it's the only section that's completely dedicated to one committee, is the audit committee. And there are lots of very specific requirements beyond the scope of today's presentation, so we're not going to get into that. But one of the key requirements to keep in mind is that there's a very detailed independence requirement. All of the members of the audit committee have to be independent under the law. And I'm getting a message that my time is up. It went faster than I expected. So if anyone wants to go through the slides on their own, if you've got any questions, my contact information is in the materials. Please feel free to reach out and contact me, and I'm available also to help you through any questions that you or your organization may have in terms of handling board and membership requirements and virtual meetings during the pandemic. Thanks very much, and talk to you later.